The Child Justice Amendments Act aims to eliminate the court's authority to impose restrictive sentences, replacing it with the discretion to assign an appropriate sentence for a child. This initiative was among the first items addressed by Prime Minister Philip J. Pierre during the inaugural sitting of Parliament for the year.
The bill basically amends Section 54(2) of the Act by replacing the power of the court to impose a sentence of 3 years with a provision which grants the court a discretion to impose an appropriate sentence. The bill also amends Section 881(3), correcting the reference to the provisions of the Criminal Code Cap 301, which has been replaced under the Act. Mr. Speaker, basically, it is allowing the court to use its discretion to impose a sentence on a child instead of what happens presently.
Choiseul Saltibus MP Bradley Felix expressed concerns regarding the power vested in judges concerning the sentencing of minors.
I thought the Honourable Prime Minister would also touch on maybe the age that we're referring to when it comes to the issue of a child, because there have been a school of thought that when you look at some of the young people, particularly early teenagers committing various offenses, that these are people who are very aware of what they're doing, unlike when you look at a youngster, say below the age of 12, for example. And maybe there should be a variation or differentiation as it relates to where the discretion should come in. Should it come in for somebody you consider pretty much a child under 12 perception, or when you look at a teenager, as whether that should be treated differently?
Viewford South MP Dr. Kenny Anthony, while partially agreeing with some of the points raised by the member for Choiseul Saltibus, cautioned the administration against relinquishing or abdicating its responsibilities as legislators.
Should we be denying the legitimately elected members of Parliament the right to offer prescriptions to the problems that we have? Should we be denying legislators the right to say what a sentence should be for an offense? Should we? And why is it that we are giving judges more and more the power to legislate and make decisions for us? A judge exists to judge on what the legal prescriptions are, not to make new law constantly on his or her own. That is why I would support the Saint Lucia Civil Code any day, and I reject any and all attempts by English-trained lawyers to abandon the Civil Code in preference of the common law. Because the Civil Code is written law. It is what Parliament and the people of Saint Lucia want to be their law. The law should not be in the breasts and in the minds of judges.
Opposition leader Alan Chasney, aligning himself with the former Prime Minister's remarks, called for greater clarity regarding Section 81 of the amendment.
But the member from Viewfort South is 100% correct. What we want and the intention of it ought to be from this House. And there should be no ambiguity in terms of what that law is saying. Now, we're confronted with a very delicate situation. This law, this act that we're speaking of, and the amendments we're proposing, are to say that a person under the age, I believe it's 12? Sorry? 12 to 18. Whether that person should receive a sentence of 3 years or more, and to give the judge the ability to do so. You know, the question is, should we answer the question, is it from the time the person committed the act, or is it from the time the person is convicted?
Other bills and documents slated for consideration included the Sovereign Wealth Fund, the Virtual Assets Business Amendment, and the Security Interest in Movable Property Amendment, as well as the Real Estate and Brokers Agent Bill and a bill titled, quote, Electricity and quote. The sitting marked the fourth session of the 12th Parliament. Gina Filippi, HDS News Force.